Bill Chatt here with the June 9th, 2020 edition of the Legal Minute. We have an interesting case coming out of 2nd District DuPage. It was published on June 3rd. It pertains to Section 15 of the Illinois Condominium Property Act, which is the section regarding sales of the association to a bulk purchaser. This kind of was a hot topic button prior to the pandemic. I imagine it still may be when things get going again. If you recall, the city of Chicago had actually, through its own condominium law, upped the percentage for sale of a condominium up to 85%. And this was kind of bouncing around. I'm going to get the case up on my screen without further ado here. It is known as Kai versus the Board of Directors of Spring Hill Building 1 Condominium Association. And so, like I said, it's Section 15. The plaintiff was not suing necessarily for a violation of Section 15 itself. Rather, the argument was there was a breach of fiduciary duty in the steps that the board undertook in executing the Section 15 process. The background facts is the layout was that there were 6 buildings, and each was its own association with its own 5-member board, and then there was also a master association. The plaintiff was an owner who owned 1 unit in 2 of the different buildings. So they owned 1 in one building, 1 in the other. So they're a member of 2 different associations, and of course of the master. The defendant was an LLC. It was clearly a real estate venture, which owned all of the units in buildings 2 and 3, more than 75% in 4, 5, and 6, and a majority in 1. So they pretty much had the numbers seemingly in their favor to effectuate their will on the rest of the ownership. That said, the defendants, the LLC purchaser, elected their officers to the boards, enabling them to control the associations. And one of the defendants' officers of the corporation was the president for 1, 4, 5, and 6, and the master. So they pretty much were in the driver's seat. Some of the points of Section 15 to remember is that unless it's otherwise stated in the governing documents, that for associations with 4 or more units, a vote of 75% in favor needs to be had. Chicago raised that on its own to 85%. I remember hearing some municipalities talking about it. Of course, there's a proposal out there regarding home rule with associations that's kind of on hold because of everything else that's on hold. So if the membership does vote in favor of the sale when presented with the facts of the sale, those who don't want to vote to sell or voted against it still have to. They still have to execute the deed and all the paperwork that goes along with the sale. And if not, then they face a lawsuit for injunctive relief to force them to do it. So there is a dispute process in Section 15 for those who do object. And so an owner who didn't vote in favor has within 20 days to voice a written, I shouldn't say voice, submit a written objection, and then they would either be entitled to receive the proceeds from a sale, which is the equivalent of the greater of the value of his interest as determined by a fair appraisal, less the amount of any unpaid assessments, charges, fines, things like that, or any outstanding mortgage on the property, less any assessments, charges, or anything else was due from the owner. The objecting owner is also entitled to receive reasonable costs related to the sale. In the event that here's where the rubber kind of hits the road on this. In the event that there is a disagreement, there is an appraisal process that pretty much is supposed to ensure that the price that's being given to an objecting owner is fair. So in that instance, the objecting owner retains an appraiser, the purchaser retains an appraiser, and then together those two are supposed to select a third appraiser. And in that respect, did I skip one here? The 3 of them together make up this panel who will vote on the actual value of the objecting owner's unit. So it gets to the point where this entity decides, let's go ahead and purchase the remaining units that we don't own. So in that regard, they start the Section 15 process. Where it starts getting problematic is that right off the bat, this association board and the purchaser, who are basically all one and the same, they use association funds for things like their lawyers and their appraisers. Right out of the bat, that is a breach of fiduciary duty. And then the defendant set up this entity to purchase those units, a straw company, as I would say. So they then called a meeting for the purpose of approving a sale of these units, and it identified this new entity as the purchaser. And what was noteworthy was owners of one-bedroom units would receive $83,475, which was allegedly a amount substantially less than sales that were occurring 2 years ago. So now you start talking about being able to prove that the value either did drop, remain the same, or whatever like that. So when you come to cases when you're talking about someone not getting a fair price, there's a fair amount of proof that needs to be put out there, and you need some statistics to show where values were, are, and why they should remain the same. Maybe the units aren't what they were 2 years ago. So there's a lot involved when you start going down that road. So some of the meetings were, I guess, cursory. In one instance, they yanked the meeting when they realized they didn't have the votes they needed. They didn't allow videotaping. So the process was looking very tainted. So plaintiff sues, defendant brings a motion to dismiss, which was granted by the trial court, hence why there's an appeal. And the main argument of the defendant was Section 15 was the sole remedy for the objecting owner in terms of getting the fair value or whatever the argument was going to be. And arguably, Section 15 is a pretty detailed section, and it's, if you read it enough times, it's kind of easy to understand how everything works, and you can kind of see there's enough checks and balances, if done properly, to ensure that an objecting owner and the association itself is doing what it should to ensure a fair price and get a fair price in the closing. So basically, the argument from defendant was, and the trial court accepted, was that all the remedies lie within Section 15 itself. What was going on with this case was the plaintiff is saying, Section 15 aside, they breached their fiduciary duty. Again, the trial court agreed with that. The appellate court disagreed, and here's where the holding is noteworthy. Looking at the totality of the circumstances, like I just said, you've got a board that's being run by the purchaser. You've got meetings that aren't being held in an open and fair manner. They're specifically not letting people exercise their right to video record meetings. The amount of the offer was lower. There's all these things that the court looked at and didn't even really look at it from a Section 15 standpoint and said, look, you breached your fiduciary duty. And what the appellate court said is important. There are instances in law where your sole remedy is. A good example is in a real estate transaction. When someone's just, normal single family residence, you're selling, I'm buying. And typically this comes out of attorney review, which supplements the contract that you sign. It'll say, in the event of a breach, the sole remedy shall be forfeiture of the earnest money. So what that means is, normally in a real estate contract, if someone decides not to go through for no good reason and breaches the contract, a seller can actually sue for what's called specific performance and force the sale through. Most practicing attorneys will, in the attorney review process, knock that clause out and say, look, if there is a breach, the only thing you get is the earnest money. So it's $2,000 to $5,000 to $10,000 that someone put down, and the prospective purchaser has breached the contract, the only thing you're going to get is that earnest money. So what the appellate court said was important. What they said is, if Section 15 was the sole remedy, there should have been specific language in that section saying it is the sole remedy, and it did not. So Section 15, while it has all this language in there, because it doesn't say it's the sole remedy, you are able to then say, hey, look, you breached your fiduciary duty within the Section 15 process, and maintain a suit. Now, that does not mean just because someone has self-interest, meaning that this factual circumstance where the board was run by the purchaser, just because that exists does not mean out of the box you got fiduciary duty, breach of fiduciary duty. If the process is fair and open and the steps are recognized, you likely, as the purchaser, could defeat that argument. the defendant tried to defend with the business judgment rule, but given the facts, again, the business judgment rule is to say, look, we did things properly. You can't sue us for a wrong decision or a decision you don't like. Typically, when you're going to argue business judgment rule, you're going to have to show that you did things properly, fairly, and openly, consulted with professionals, things like that. There's more to it than that, but that's just kind of the synopsis of it. Well, that was rejected out of hand by the court anyway. Again, because of the process itself. If you read the case, which I will post, it wasn't fair and open. It's also the decision is also noteworthy because, as I said earlier in this recording, the process for an objecting owner is within 20 days to provide written objection. Then you start the process with the appraisers and all that. In this instance, apparently, the plaintiff did not timely get the objection on file. So normally, if everything else was done properly, if you don't exercise your right timely, let's say in the instance of when a budget is 115% or more over last year's budget, the owners can call a special meeting for the purpose of rejecting it. You have to do that stuff timely. And here, this plaintiff did not timely get the objection. And so the defendant made the argument, well, you'll always be able to make an end around of the Section 15 process by just claiming breach of fiduciary duty, which I think arguably you could say, yeah, that's a possibility. But again, if it's done properly, you would think that could be disposed of relatively quickly. So again, this plaintiff had not timely got their objection on file, yet they were able to sustain, not at least at the trial court they weren't able to, but now with this appellate court decision, they were able to get a suit going based on the breach of fiduciary duty. And again, I think if you read this case and you read this holding, you're going to see the appellate court said, look, this one's a little bit beyond the pale in the way this all ran. And that is what allowed this plaintiff to actually get a breach of fiduciary duty around the requirement that the objection be filed within 20 days. So the case was remanded to the lower court. This is not necessarily done. The plaintiff still has to make all the proofs with regard to the breach of fiduciary duty, but it is noteworthy in that the process itself, if it's not done properly, you're going to be able to sustain possibly a breach of fiduciary duty case. And that's something that you'll just have to look at if you're involved in one of these situations where the association's for sale. So until next time, that is it from here. And I will post these notes as PowerPoint, and I will post the case itself on our website, which is ccpchicago.com. Right on the front page, you'll see a link for video webinars and archives, and that's where I will post it. Take care.